I'd like to call this meeting to order. This is the Vision Committee, and we're going to be hearing about the changes that the legislature has made to police matters, and that should be a pretty interesting topic tonight. And if we could get a roll call, please.
Certainly. Good evening. Mayor Pro Tem Hamrick,
Here.
Councilmember Dennehy,
Here.
Councilmember Gonzalez, Councilmember Jaquez, Councilmember Meisner, Councilmember Reed, Councilmember Brandon Smith,
Thank you very much. This is the Vision Committee meeting, and so there's not going to be any formal actions taken tonight. It is for informational purposes, and because of that, we don't have to worry about having a quorum. And with that, I would go ahead and turn this over to our attorney, Catherine and Sellers, and if you could get us started, that'd be great.
Sure. Thank you, Councilmember Hamrick. So today we're going to discuss the new law enforcement integrity legislation that was adopted by the legislature and signed by the governor in July. So as you know, the contents of the bill include new use of force, deadly force, and standards, new criminal and civil liability for officers, regulations on camera usage and operations, and reporting requirements, and lastly, some new operational standards. So today, we are only going to discuss 4 of these things. And the reason why is that the camera requirements do not come into effect for 3 more years. And so I'm happy to answer any questions at the end about those, but it's not going to be the focus of our discussion today. So starting off, use of force. So this is the new definition of physical force that appears in the bill. Notably, this actually does not appear in Title 18 where the use of force, deadly force provisions are. It actually appears in a different title, but it's part of the bill, and we assume that it will be the definition that's used for use of force provisions. So we've had a call with some DAs, and their current interpretation of this definition is anytime an officer put hands on someone to get them to do something they are unwilling to do. So handcuffing a willing person or taking a compliant person to, to a vehicle or something like that is not physical force. So physical force is permitted under the legislation when nonviolent means will be ineffective to do these 3 things: effectuate an arrest, prevent an escape, or prevent an imminent threat of serious bodily injury to the officer or another person. That language that's underlined there, the nonviolent means will be ineffective, that is a new standard, and we're going to be talking a little bit about those thresholds that the bill puts in place and how they may affect how the case law surrounding use of force cases, how it could change that. So I want to compare the old and new language in the use of force provisions. So here's the old language on the left and the new language on the right. So there's that new threshold, and you'll see that reasonably believes it is necessary has been eliminated. And we'll discuss later on, but that language is pretty important in the case law surrounding use of force cases. So these are essentially the same: to effectuate an arrest, to prevent an escape, and to prevent imminent threat of seriously bodily injury or death to officer or another person. It's pretty similar to what is in the statute, or what was in the statute. So it's really that first section that's really, really important. So talking about limits on use of force. So no deadly physical force to apprehend someone who is suspected of a minor or nonviolent offense, including misdemeanors or felonies which do not involve the use of threat of deadly physical force. So it's a pretty narrow selection of potential, if someone's suspected of a potential scope of crimes, it's pretty narrowed now as to when deadly physical force can be used. I think what I've heard from officers that, is it's a minor offense to start with, and it escalates to something that's maybe a felony with deadly physical force. And so it's changing on the scene for the officer. One of the questions that's come up in this discussion since the bill was passed is, what is a minor or nonviolent offense? That's a great question I don't have the answer to. Those are undefined under the bill. I think, we can assume that speeding is a minor offense. And a nonviolent offense is something that doesn't involve physical force against another person. So a property crime could be a nonviolent offense.
So can we ask questions?
Absolutely. I'm sorry. Yes, feel
Sure.
free to ask questions anytime.
Great. So along those lines, you mentioned speeding. What about eluding or high-speed eluding, especially when it is a threat to the public?
Yeah, so that's a really tricky situation. There's I think law enforcement and obviously Sergeant Walsh is here to speak to, but I think it is really tricky because from a lawyer's perspective, the threat to the public is a very generalized threat in those situations. And so I think officers are going to have to take that into consideration. Are there other people on the road? Is the road clear? All those factors. And, there are going to be times when a court could find that the threat to the public was too generalized and just wasn't there, to be honest. I think that's going to be really tricky.
Mr. Hamrick, the guidance that we've been giving officers currently on this is that if it is not a felony, it is a minor offense. Further, even some felonies would probably still be considered a minor offense under this bill. For example, first-degree criminal trespass of a vehicle is somebody breaking into a vehicle with the intent to commit a crime therein. It basically means that they're, stealing your loose change out of your cup holder or something like that. That is a felony. However, I don't believe that would qualify as a significant or major offense under this law. That certainly isn't a violent offense.
And so just a further question here. And so the problem facing our officers is that we're not going to have a list of minor or nonviolent offenses. That's going to be determined through the court system, which means essentially officers at risk until that is a settled issue.
Yeah, I mean, at least that's the case right now. And I'll probably say this about 3 times today, but I fully expect the bill to be tweaked as the years go by. And so, it'll be a little bit of a moving target, which of course is not helpful to officers at all. I think additionally, the other issue that I've heard is, in your eluding situation, so, it starts with maybe a minor offense and now they're eluding. And, I think a lot of officers are like, well, maybe we shouldn't chase because we're creating the danger. He's eluding us. And if we know where he is and we know where he lives and we know where he's going, we just go later to that place and try to find that person, that suspect. And trying to manage those two things as to, are they escalating the issue by chasing?
Yes.
Yeah. So.
And that opinion would be consistent with current policy anyway.
Mm-hmm.
So another limit is that the degree of force must be consistent to minimize the injury to others. The others includes the suspect in this case, or at least that's the current interpretation of the bill. As it's been much publicized, there is now a prohibition on chokeholds. This is the definition of chokehold here in blue. I won't read it, but it is basically any time, any pressure that would limit breathing. So it's not just the neck and throat or windpipe, no carotid holds, but sitting on someone, kneeing someone in the back, anytime someone can't breathe is going to be a chokehold. And that definition is broader than what it currently, a lot of policies define it as. So that's a little bit of a change. The interpretation, though, is chokeholds can be used as deadly physical force to defend the officer or if someone else is an immediate threat.
And just could we get the light turned off over the screen? That would. It's a little bit hard for me to read the blue.
It's not the lights, John.
Thank you.
Oops. And then additionally, there are some limits on use of force for protests and demonstrations. So no discharging kinetic impact projectiles or other non or less lethal projectiles targeting the head, pelvis, or back of an individual. No indiscriminately discharging them into a crowd. And no chemical agents or irritants unless the law enforcement has issued an order first and repeated if necessary, and then allowed sufficient time and space to comply. My presentation did not have sound effects, but it does. This is the deadly force provisions, and that's arrest and defense. So first we're going to talk about arrest. So again, the bill puts this immediate kind of threshold when all other means of apprehension are unreasonable. So the officers are required to kind of, in their minds, make that decision. And we'll talk a little bit about how different that really is for officers when they're performing their duties and have their current training. Only in an arrest for a felony involving conduct for the use or threatened use of deadly force. And the suspect has to pose an immediate threat to the officer or another person, and the force employed does not create a substantial risk of injury to other persons. Just a kind of note, a legal note, is that "and" that you see there after person does not actually exist in the bill. This is how poorly written it is. And so we are assuming that that "and" is meant to be there based upon just kind of reading the bill.
So that, and that would contrast with the word "or," if the word "or" was used.
Yeah, we don't think that that is what was intended. We think the "and" is what was intended.
And the difference is that the "or" means that any one of those would be, would mitigate against using deadly force.
Yeah.
Whereas "and" requires them all.
All
to be.
three, yeah. And this other person's, obviously, unlike the others in the other section, this other person's does not include the suspect. So it's just the members of the public or other people around or even other officers. So deadly force is, of course, also allowed in defense of an officer or someone else. You'll notice that the objectively reasonable belief is actually in this section. I don't know exactly why it's in here and not elsewhere, but it is in here. And they have to reasonably believe that a lesser degree of force is inadequate and have objectively reasonable grounds to believe that they are in imminent danger of being killed or of receiving serious bodily injury. So this is similar language that's already actually in statute. The self-defense statute, which is Part 704 of the same title, which has been applied to law enforcement. So it essentially copied that section and put it in here. So not too much has changed with this. There is a warning requirement in the bill. It's a pretty insignificant portion of the bill, but I bring it up because it's a demonstration, I think, of how poorly the bill is written. So the officer is required to give a verbal warning of their intent to use deadly force and obviously identify themselves. But the threshold for using deadly force, as we just discussed, is very high. There has to be an imminent threat. You know, they're trying to effectuate an arrest. And so it's a very high threshold to give the warning. But the issue is that the exception, the unless to do so sentence, is extremely low. It's any risk of injury to the officer or create a risk of death or injury to other persons. It's not imminent, it's not immediate, it's not serious bodily injury, it's a much lower threshold. So it essentially negates the warning requirement. I know that a lot of law enforcement are trained to give this warning already, and so we have advised our clients to go ahead, give the warning as you've been trained to do when you can. Obviously, giving the warning and waiting for it to be observed in some situations, there isn't enough time. So in those situations, they just, and this exception allows for that, but it's poorly written. Any questions on use of force? Because we're going to kind of shift to the duty to intervene. No? Okay.
Well, the only thing I looked at, that I was going to question is going back to breaking, or, you know, hurting businesses and that, do there still have to be a wait time for them to, you know, that's what, that bugs me. Do you see what I'm saying?
So first, the ideal situation, if we had to use some sort of chemical munition to disperse a crowd, would be to disperse that crowd before it elevated to the point where there was damage being done to the business.
Sure.
Part of our policy and part of best practices nationally, if you look at the NTOA, which is the National Tactical Officers Association responsible for SWAT training across the country, is to already give a warning and provide time for that warning to be complied with, as well as provide, we call it an escape route, but some place where people can go to escape
Right.
that gas anyway. So what we're talking about here is really codifying something that's already been in policy and best practice across the country anyway.
Okay.
It really doesn't affect how we would use that. God forbid we should actually have a scenario where that was required.
Sure. Thanks.
Any other questions?
I would just like to share something that I saw that made quite an impression on me, because I think it's really germane to this whole topic, and points out the decisions that police officers have to make, sometimes not even with seconds to make the decision, but immediately. But there was a house with a driveway beside it. I saw this on TV, so excuse me for that. But there was a house with a driveway. There was a suspect standing basically in the middle of the house. There was a police officer confronting the suspect. They had been chasing this guy. A police officer confronting the suspect. Unbeknownst to the suspect, another officer came from the other end of the house and was looking at the suspect's back. And the suspect and the officer were facing each other. And the third officer yelled "gun" just as the suspect made a move. He did have a gun. It was a single shot situation where the suspect was neutralized. But it was essentially like that the decision had to be made. And, you know, in my view, you know, adding additional restrictions to officers may not be the best for our police departments. I just wanted to share that.
And I think well, from my perspective, and I'm obviously not a trained law enforcement officer, but from my perspective, I think the biggest question for us is, does this law really change anything? I think that's like the ultimate question. I mean, and we'll talk about it a little bit in a bit, but this change in language, you know, lawyers, we get all caught up in the words, but, you know, is it signaling that the courts will do something differently? Or are the officers already, when they're making decisions, they're already, they're in their minds in those milliseconds, deciding a lesser level of force is inadequate? I mean, they're essentially doing that already, and I think that's the big question, and I don't necessarily know the answer to that, and I think that's really probably a question for law enforcement, because, you know, I haven't trained law enforcement either, but, so I think that's really the question is this really any different, or is it really codifying what the training has put forth already?
Gotcha.
And I guess the other thing I'd say is, one way I look at this is, this part of the bill is in the criminal statutes. And it is meant to catch that small percentage of officers. Like most major crimes, like, you know, murder, not everybody's going around, it's meant to catch like a very small percentage of the population. And I think this is that too. I see that in kind of this way. It's really meant to catch that really small percentage of officers and not, you know, cast as wide a net as I think it maybe appears to be on the surface. And that kind of goes back to, is anything really changed here? And so part of it is a little unknown because we don't know what the courts will do. And we'll talk about that in a little bit, but you probably should hear from law enforcement on the training part.
I would tend to agree. Many of the provisions within this bill, it makes an explicit statement or restriction in one section, and then a few paragraphs or another section later, it removes most of that restriction. For your concern specifically, federal case law in Graham v. Connor, which is the case that the Supreme Court decided that governs the reasonableness standard, which governs almost all use of force incidents with regard to law enforcement, explicitly states that the courts will recognize that officers are required to make split-second decisions. Now, obviously, that's federal, but in the vast majority of the cases, that should represent binding precedent on the state supreme, appellate, and district courts.
Any more questions? No? Okay. So the bill also imposes a duty to intervene on officers when another officer is using more force than is permitted under the statute, if any force is even permitted. It's when excessive force is being used for arrest, taking a person into custody, booking, or crowd or riot control, and it's without regard of chain of command, which means the officer has an independent duty to intervene regardless of what the commanding officer is telling them to do or not telling them to do. The officer must report the intervention after it occurs. The statute currently includes a reporting requirement for excessive force, and they mirror one another pretty closely. And then the officer may not be subject to discipline or retaliated against for reporting, for intervening, or failing to follow an order of an officer reasonably believes to be unconstitutional. Failing to intervene is a Class 1 misdemeanor for the officer. When an administrative law judge in an internal investigation finds that an officer failed to intervene, that finding has to be provided to the DA. And if the DA does not charge the officer, the DA must provide a written statement as to why.
To who?
A public written statement.
Just a public written statement. Thank you.
Yeah. And then if the same finding that the officer failed to intervene and the incident resulted in serious bodily injury or death, the employer must discipline the officer, and the post board permanently decertifies the officer upon the notice of discipline. A couple of things to note here. It does not dictate the level of discipline by the officer's employer. It just says they must discipline the officer. And the decertification by the post board can only be overturned by exoneration by a court. What's problematic here for an officer is that exoneration requires a criminal process, but the decertification doesn't require criminal conviction. So it could turn out that the DA doesn't charge the officer, but the incident involves serious bodily injury or death, and the officer failed to intervene. He gets decertified, but he cannot seek to have that decertification overturned because there's no means for him to do so. This is another area I think will probably be fixed in future legislative sessions. Okay, on to the big portion. So the bill imposes civil liability on a peace officer. It's very similar to what's called a 1983 claim, which you've heard us probably talk about under federal law. So it's basically an officer who deprives someone of their constitutional rights under the color of law, so acting under the provision of law, but it's connected to the Bill of Rights of the Colorado Constitution instead of the federal Constitution. So, excuse me, there is no qualified immunity, which has been much advertised. So although qualified immunity is not a doctrine in Colorado State Court, this essentially prevents the development of the doctrine. That's how we're reading it. So qualified immunity, just for clarification, is a jurisdictional bar to bringing a case. So if an officer has qualified immunity, the case never goes to trial on the merits. This is different than what we're going to talk about, what Sergeant Walsh alluded to earlier regarding Graham v. Connor. Because, go ahead, sorry.
I'm just going to ask a question on that. So in the first paragraph, where are we in law if the actors are reversed? And we say any citizen who under just, and perhaps drop out the under color of law, but any citizen who subjects or causes to be subjected, including failing to intervene, et cetera, against a police officer is subject then to legal or equitable relief. Where is there, how does that,
That does not exist.
it does not exist?
It does not exist.
A
at
citizen
the-
has no duty to intervene on behalf of another person in the state of Colorado. So therefore, if a citizen was witnessing, for example, a suspect commit an assaultive act against a police officer, they're not required to do anything. They are not even required to call 911 or assist in any way. If a citizen was assaulting a peace officer, they are subject to criminal prosecution just as anybody else would under the assault laws.
And so, but that's my question here, because this is legal or equitable relief, which turns it both criminal and civil then, is that correct?
Well, actually, this is just a civil statute, so this is not a criminal
It's not
statute at
criminal,
all.
so.
But
so-
equitable relief could be something like, oh, the court orders training of the police department where the officer came from, because maybe it's a pattern of behavior or something like that. So that would be like injunctive relief is equitable relief.
And so my question is the essentially, citizens can go after police officers and target them and be subject only to the criminal liability, whereas this creates for police officers a civil liability, and there's no such, parallel or similar provision of this legislation.
Right, and I think, so the reason, well, at least in the sense of like constitutional law, the reason for that is when the government is acting, it's always subject to constitutional parameters. When an individual acts, they aren't necessarily. It kind of depends on the context. And there has to be some kind of cause of action or statute that makes the private citizen's behavior discriminatory or violating someone's constitutional rights. And so it's much more limited for private citizens. And the government, when the government acts, it's even as an employer, it's always subject to those parameters.
Understand.
So that's just the way the system works. So-
The cookie
and-
crumbles.
Yeah, and there's no federal counter component either. So, yeah,
Yes, thank you.
sure.
Theoretically, the police officer who was assaulted could sue for damages in civil court on their own.
Yeah, it just wouldn't be a constitutional. So like Colorado governmental immunity protects the government from torts. Private citizens don't have that protection.
Don't have that
So, you could sue someone for damages for emotional distress if they assaulted an officer or something like that, so.
Thank
Just
you.
wouldn't be a constitutional violation. All right, so this section of the bill removes the applications of the Governmental Immunity Act I just alluded to acts of police officers for constitutional violations. So what is important to note here is that it is only police officers. It is not the entity. So the municipality would not be sued under that provision, at least not the way it's worded now. And there's no caps on damages, which is like it is at the federal level. Before I get into the federal case law, because of these provisions and the lack of qualified immunity, we expect to see these cases start coming into the Colorado State Court and not go to federal court anymore. Because obviously without qualified immunity, that's one less hurdle. So that being said, we shift to the applicable case law. So we assume for now that Colorado courts will adopt the analysis in Graham v. Connor regarding the reasonableness of force, but the new law could affect the application of those factors in Graham, which is what we're going to talk about for the next couple of slides. So the Graham court held that the reasonableness test is actually the one under the Fourth Amendment to determine whether the officer's application of force was excessive. And that analysis is, for better or for worse, is very fact specific. So it is not, there is no bright line rules for officers, which makes it even more complicated. And then one thing, and one thing to note about the reasonableness test before we get to the factors is that it is the perceptions of the reasonable officer at the scene. So it's not a look back, it's not 20/20 hindsight, it's what that officer is experiencing at the scene. So the first factor is severity of the crime, whether the suspect poses an immediate threat to the officer or a third person, whether the suspect is resisting arrest or attempting to evade arrest. So as I mentioned, the test doesn't always give clear answers, and this is the U.S. Supreme Court on another use of force case talking about Graham and the Graham test, and that it's the nature of the test which must accommodate limitless factual circumstances. So if that gives you an idea of where that lands. In addition, the 10th Circuit has also established certain factors for deadly force cases to assess the threat to the officer. And we suspect that the state courts will adopt this. This is probably less affected by the bill. But, you know, there's that warning requirement again, hostile motions that were made with a weapon towards the officer, the distance separating the officer and the suspect, and the intentions of the suspect that they've manifested. So just taking a look at Graham more specifically in the factors and how the new law could maybe tweak those factors a little bit or could change them. So the severity of the crime. So instead of just being the severity of the crime, the law now delineates certain crimes in certain categories. And so that's going to tweak that factor more than likely for the court. Whether there's an immediate threat to the officer or third person. So I don't know if you noticed, the law kind of switches between immediate and imminent. Imminent is going to happen. Immediate is basically happening. And as John pointed out, you know, there's seconds between when something becomes imminent and immediate. But an immediate threat it has to exist for the use of deadly force in general under this new bill. And the lower threat of imminent danger must exist for deadly force in defense. So that's another tweak. And then whether the suspect is resisting arrest or attempting to evade arrest. So these are those kind of thresholds that I was talking about earlier, you know, so there's these parameters that nonviolent means must be ineffective, force must be consistent to minimize, deadly force in defense may only be used if a lesser degree is inadequate, and no deadly force in preventing escape. That's that fleeing felon rule that's been removed from state law. And so we think this factor, I think this factor is the one that could change the most over time to kind of fit within these parameters just a little bit more consistently with the bill. Although I am predicting some tweaks here, it could be 20 years before we see this play out. The cases have to make their way through the court system, and so we don't really know. And to be frank, plaintiffs' counsel, if they want these tweaked, they're going to have to come up with something new for the court. The court is unlikely to just create new factors on its own. You could have a judge do that, but courts like to have guidance or a route if they're going to change anything. So right now, I think the assumption is Graham v. Connor applies and law enforcement should operate under those factors until we know differently. They have been in place since 1982, 7? Yeah.
I believe Graham v. Connors dates to the 60s, but I would have to look that up.
Oh, I don't think, okay. All right, so indemnification by the employer. So the city is required to indemnify law enforcement except under two circumstances. If you've determined that the officer did not act upon good faith and a reasonable belief that the action was lawful, or when the officer was convicted of a criminal violation for conduct from which the claim arises. On that first one, so the law just uses the term employer, and so this is something you all might want to think about who that is. It doesn't require it to be anybody specific, but it can be council, it can be, some communities have delineated it through the organization where like the chief would make some decisions. You know, if a use of force is involving the chief, it would go to council maybe or something like that. So that's something you should probably start thinking about, whether or not you want to delineate that out. You're not required to. It can just be city council all the time. So if the city were to find an officer did not act in good faith and reasonable belief, and if we were presented with that currently, I would, and Corey and I would help you in your decision-making, hopefully, for that good faith and reasonable belief. We would use those Graham v. Connor factors in making that choice and helping to provide you legal advice on that until that law changes. So if that's the case, the officer is liable for 5% or 25% of the judgment, whichever is less, so it will never be more than $25,000. If the officer's portion is uncollectible, the employer or the insurance shall pay the portion. I put in quotes uncollectible, it's not in the bill like that, but I put it like that because I don't know what that means. That could mean anything. And it doesn't say who makes that choice. Does the employer make that choice? Does the officer make a case for that? It's completely unclear as to how that decision is made or when it's made, because obviously if you've ever done any kind of credit or debtor work, you know that judgments can be renewed over, up to 20 years. So it's not clear exactly how this plays out. And frankly, I think a lot of lawyers are of the opinion that it's essentially meaningless in some respects, because the employer can always, just say, no, I'm going to do it, which is what happened in Greenwood Village. They basically come out and said, we're never going to do this. We're going to cover our officers.
Florence recently passed a very similar measure.
So the first one, I just want to point out, this is a shall. So the officer shall be liable if the employer finds that they did not act upon good faith and reasonable belief. However, if the officer is convicted of a criminal violation, it's discretionary for the employer to determine whether to indemnify or not. So the employer can say, nope, I'm not indemnifying you at all. The employer can say, I'm going to indemnify you anyway. I think that jury was wrong. I think that court was wrong. So that's another weird part of the bill.
So a question on that, is that, looking to the future, is that something best left alone until a particular jurisdiction faces that question? Or is it worthwhile putting some thought into that and trying to get some policy in place, or perhaps city rules or something?
I think it's valuable to have the conversation now. So my general rule of thumb in life is plan your divorce when you're getting married, because you're happy and you're getting along and it's all great.
I think they call that prenuptial also.
They do, but I think it applies here too. You don't want to be faced with like, oh, we should have delegated this authority, when you have a case in front of you and you have to make a decision. Right. So that's my suggestion. And I think in addition to that suggestion, I would recommend working with your insurer too, because what is kind of silent here is the practical realities of how any civil liability case, when a case is brought against a governmental entity, plays out. You have your insurer picks your, defense counsel, and your insurer is having a big role in your decision making. And so, the insurer is gonna affect this decision quite a bit, regardless of who's making it. And that part's just a little silent because they can't legislate that situation. So CSRSA is going to have a big say. So I think I would do a policy now, and I would also bring CSRSA in on that conversation and pass it by them and see if they think it's okay.
And then, so just a further question along that line then, Ryan, is that something that a ball that you think is in your court, or would you be looking for some suggestions from council, or not touch it, or what are your thoughts on that?
Yeah, I think we would want to see some guidance from council, and then pick it up, and I would work with the attorneys and the chief to work on some type of policy based on council's guidance.
Yeah, I think we gotta do something.
Yeah.
I like that.
So that's.
Get divorced.
Yeah, let's plan the divorce.
It will, if you encounter a case that is high profile, it's already going to be tough to make those choices. Right. And so having a policy just puts you in as good a position as you can be in under those circumstances. So.
Great.
All right. So any questions on the civil liability indemnification provision, because we're gonna move on from that? No? Okay. So we're gonna talk really briefly about some reporting requirements. So this is in effect now. Law enforcement is required to report, and it's only an internal reporting right now. Anytime they make contact with an individual, they have to provide all this information regarding the demographics of the person they had contact with. And there's a long list, and it's not in the slide. But it's anytime they make a contact for purposes of enforcing the law or investigating a crime. I have a lot of police departments who are like, well, what if I'm just talking to someone like about the weather? Well, that's not a contact. But I think law enforcement used the term contact much more broadly before. And so this is a much narrower definition of that word. So if they're not doing those two things, they don't need to do the demographic reporting. And then,
What is our police force? What are we doing now? Has that already been in effect?
We have already put that in effect. As soon as we saw this provision come out into the bill, we sent directives out to our patrol officers along with the specific information. This information it's possible to collect this with the records management system that we currently have. So if an officer completes a report on a given contact, they would include that within the report. Normally, prior to this legislation, if we just contacted somebody to see what was going on, a suspicious incident, something that did not elevate to the level of a report, we may not have collected all of that information. However, the officers have been directed now to just collect all the information and enter it into the RMS system in a field interview card or some other method.
Is that onerous to have?
It's something that takes 2 to 3 minutes per contact. So over the course of a shift, I won't say that it's difficult, but it's noticeable to the officers.
With your software, and they have to put the person that they were in contact with, does that software allow just to look at that person and what kinds of contacts that they've had with officers?
Yes.
And is there written guidance on that? I mean, we haven't gone over the factors right now, but has the department developed written guidance for the officers to know when and what to collect?
Yes, there was an email that was sent out initially with all of the appropriate information and a directive to collect it. And as part of this legislation, we are mandated to have training on the legislation completed by August 31st. I have, I think, 7 or 8 officers that have not yet been through that training, but as part of that training, they are given a handout that includes all of the requirements for the reporting.
Does there exist in the Department of Standards or Policies manual where this will be recorded?
This will end up eventually in the policy manual. It's not there yet. That requires quite a bit more work, but it's headed there.
Thank you.
and then there will be reporting requirements starting about 3 years from now to the Division of Criminal Justice. It will be that same contact data reporting that's mentioned above, and then including 2 more reporting requirements: use of force resulting in serious bodily injury and death, and resignations of officers while under investigation for violating department policy. The second one, I also see changing because that's actually the wording from the bill, violating department policy. So it could be anything, and that's probably, I think, broader than what was really intended. So I suspect that law enforcement will push to see that tweaked a little bit and refine what policies really trigger that reporting requirement. But as I mentioned, that's 3 years out. So as Sergeant Walsh mentioned, law enforcement must finish all training by September 1st of this year. Failure to complete the training could result in revocation of the officer's certification, so it is important. And then there is a current, in effect now, requirement for business cards that they have to have information on how to file a complaint related to the contact. And the statute requires information regarding complaints or commendations related to traffic stops, so the business cards have to include this too. It's an additional requirement. So it's a little, it's a lot to put on a business card, to be frank, but, so this is in effect now, and I know that law enforcement are trying to get new business cards out to get that sorted, so. So that's the end of my presentation. I'm happy to answer any questions that you have.
And would you back up to that last slide too?
Sure.
Sure, go ahead, Jim. You had a question?
No,
Oh.
I did
You
not.
You got really ready there. I thought you
It looked like you
did.
were ready to jump right in.
Well, I'm still contemplating the divorce thing here. I'm
Yeah.
trying to figure out whether I did right or wrong.
When do officers have to provide a business card to a citizen?
When they make the contact. That's the way I read it.
I believe that is actually restricted just to traffic stops, when they do not otherwise issue a citation or some other written documentation. That's consistent with the current law. Really, the only thing that changes here is the wording that's required on the business cards. For example, our business cards already have information on how to make a comment on the traffic stop and that sort of thing. Unfortunately, it does not include the word complaint. So on the next purchase of business cards for the department, we'll of course modify that so that we're in compliance with this. Currently, we have stickers printed out, and the officers just have the sticker on the back of their card that says, also for complaints, call this number. And our reading of this is that that will comply with this current restriction.
And it's clear, it's not clear to me, and that's why I'm asking, but it's clear to the officers when they have to provide that business card.
It is. That is explicit in the training that we've been putting out. Further, what we've really been recommending is just put the stickers on the back of all of your cards and don't worry about it. You already have to give the cards out on a lot of contacts anyway. It's done.
You said that's exclusively for traffic stops?
That is the requirement, is exclusively for traffic stops. That is in.
I think we should probably talk about that because the problem that, as a lawyer, that I'm having with that is the contact is a broader concept than the traffic stop. So I think we should probably take a close look at that and
And
make sure.
that was where my ill-defined area of concern was here is on when is the contact? And so I would ask the question, Sergeant Bell, so has the training been reviewed by our attorneys? Is there interaction going on there? Just this as a general matter in regards, specifically in regards to this too, but it's to make sure that we have a unified thinking between law enforcement and our legal team on these matters. That's my question. Is there some review that's going on, or how is that working?
We
So-
have reviewed that with command staff. I don't know if that was reviewed specifically with the city attorneys. It is training that was adopted from Pueblo PD, and I believe that Pueblo had theirs reviewed by their attorneys. However, I can't say that it was reviewed by us unless you've seen that training.
No, I just received the use of force provisions for the modifications of that, so I've just started reviewing that. But we can review all the changes in the policies, so we're here for that.
Is the person that drives that, is that going to be Ryan? Will that be you, Ryan?
Actually, it'd be the chief.
The chief. Thank you. Okay, great.
So for the record, I'm looking at the bill right now, and under one section that deals with the business card, it specifically states, provide a business card to any person whom who the peace officer has detained in a traffic stop but has not cited or arrested. So it does not necessarily pertain to other contacts.
Is that
In-
it?
I'm
oh,
sorry,
go
go
ahead.
ahead.
I was wondering, is that the intention, is to try and see if they're profiling and pulling people over, or what?
That would be my assumption. That's also likely going to be part of the use of the demographic information collection. However, there's nowhere in the bill that shows what the state intends to do with that information once they have it collected.
So under the bill, the Attorney General can bring an action against a municipality for a pattern of behavior in law enforcement. And so I suspect that's what that data will be used for, to see if there's a pattern of behavior.
Sure.
I'm a little surprised that we are training our officers in regards to this bill, and the content of that training hasn't been reviewed by legal. That, to me, from my outside perspective, doesn't make a whole lot of sense, with all due respect. That we're
the
trying to make
council-
for sure that they're understanding the legalities of the bill. I'm going to defer to the administrator, but that doesn't make any sense to me.
If the council and the administration would prefer that we pause that training until the attorneys have a chance to do that, we can do that. And if necessary, then we can go in and modify that training and provide retraining for the officers that need it. That's not an issue for me, at least in terms of providing that review.
With all due respect, I'm not questioning your training, even though I am, but it just seems odd that we're doing training on a new bill that's not been reviewed by legal.
It's a layer of protection for our CCPD too, right? That it has been reviewed by legal to make sure that we're providing.
Yeah, I mean, we could be, for example, the business card thing, we've obviously got a difference of opinion here about when that maybe would apply. And I don't know how many other areas we have where we have other individuals other than our legal staff kind of making some critical decisions that down the road could be detrimental to the city and the staff.
Either Sergeant Walsh or Interim Chief Wagner, if you want to, I don't know if you want to go up to that podium over there. Can you talk a little bit about how many areas of training have been modified because of this new legislation, and how quickly that was implemented?
It was implemented very quickly. As soon as we got information from Catherine as well as from Corey, we immediately put that out to our folks. Started meeting with our shift briefs. The information that did come from Pueblo PD, Pueblo is what we refer to as our Central Mountain Training Region. They're who we refer to in most all of our training. So we rely heavily on what they provide to us. We also took an effect what Catherine sent to us in email. We also put that out as well. When we talked about the labels that we attached to our business cards such as that, those went out immediately too. So we do have those available. We did read in that ruling, it was traffic stops. And yes, I would probably refer to as what they're looking for is anyone that's referring to as probably racial profiling is what they're looking at, I'm sure. But we are making sure we're documenting everything in our reports, FIR cards, those, as soon as they responded to us, that went out immediately.
Well, I think there's a difference between immediate distribution of information to get people up to speed with an immediate change and a documented training program. I think there's a difference between those two, that if something that you're going to address in roll call or whatever you're going to call your morning meeting or your beginning shift meeting, I think that kind of dissemination of information is different than a formal training that you're accrediting officers with.
And this is coming from Post still. This dictation is coming down from Colorado Post, who we rely on heavily. Everything that Pueblo is going to put out, that's also going to be coming through Post. And again, I can't qualify if it was reviewed by their legal, but obviously we can go back through our legal and make sure that they review this material before we do put it out. So we can't halt that until they do take a look at what we're putting out.
And if I could, I think essentially what this legislation has done is put the cart in front of the horse. That there are, September 1st and immediate implementation of some of the provisions of the law
Yes.
are the anathema, are anti-ethical to being able to develop training standards, have them reviewed, implement them in a thoughtful and timely manner. But that's the situation that we've got. I hear your concerns and I agree, but nonetheless, with the September 1st deadline, there's something that has to be done. And I think that we should commend our command staff and our attorneys for working on this and getting something to the officers because there's, the time is quickly approaching. That doesn't take away the necessity of making sure that we follow the right steps and that we have the right reviews to implement this, even though the legislature has not given us that benefit of the doubt or time to do it.
Do we, in fact, get some kind of legal support from this training organization in Pueblo?
We absolutely, like I said, CMTR and Pueblo PD, that's who run that regional training. We don't get legal support like we do with Catherine and with Corey, but all of our training for posts comes through them. That's who we rely on heavily. So they are vetting this stuff as it comes out.
So, and there's different types of training, obviously.
She
Like,
keeps making reference to post, but
Yeah, so POST is
Right.
the board, right, it's the state board.
Yes.
And they're gonna issue training, and there's obviously training we don't do, the field training and that kind of
Right.
stuff, like, we don't touch that. So, and I'm not disagreeing with you, Councilmember Meisner, but a lot of police forces are kind of, like Councilmember Hamrick is alluding to, it's kind of a jumbled mess, and things are not.
I'm in the same situation.
Right, things are not in the right order, and law enforcement is, trying to get it all together and things like that. And I have faith that we will get what we need done by
Yes.
September 1st, and officers they'll have a new use of force policy, which they'll be trained on, and we will get the components in place. So I have faith that will happen.
So you're saying, Mayor Pro Tem, it was a gunshot wedding that we were forced into, and now we got to align our goals and our
Because if you
and our priorities as
recall,
a marriage together.
Well, and this is actually better than the other previous versions of the bill, which
Right.
were
yes,
shotgun completely. I mean, a lot of this stuff got delayed, which is, we didn't even talk about the body cameras and all the disclosures of the body cameras today
Correct.
because it's a mess. I can't even understand this section, so I'm hoping to see a lot of tweaks to that in the next 3 years. So luckily, the law enforcement lobby was able to push things out just a little bit at least to get some time, so.
The other way to say that is that it's very difficult to negotiate prenuptials when it is a shotgun wedding situation.
yes. And the bill,
Catherine's.
and when the bill was signed, it was immediate. I mean, we had to
Yeah,
get
and
these out
he
quickly
Right.
signed it very
on a
quick.
Friday.
Well, yeah, and I think it passed the legislature that week, so, we
Yes.
were expecting him to sign it pretty quickly. But it happened on a, Friday or Saturday or
Yeah,
something
it
like that.
was,
so,
yeah, and we
Yeah,
had to get it out as soon
I
as we
spent that
could.
weekend reading the bill, that was super fun, so.
Yes.
Yeah, I understand the knee-jerk and immediacy of the politics in Denver, but, we're left with the problem, so we still, my point is, we have to be careful with our training that's not getting reviewed by the legal staff that's representing the city and the staff. And if Pueblo's given us training, there needs to be some legality there that the training that they're giving us is constitutional training.
Yeah, and I don't know what the post-training looks like, but, so post is actually charged under the bill with providing the training. And so I'm comfortable that what they provide will be adequate. I don't know
Yes.
how much of it goes into the constitutional issues or that kind of thing, because I've never seen it before, but, I mean, I think, you know, what we're talking about now is tweaking the use of force policy to make sure it matches the language in the statute. And that is something we've been involved in with every one of our clients, and we're involved in with Canyon. And so that's where we really get involved, is in the policy drafting and the writing, and then law enforcement takes that and trains with it, right? Is that correct? I won't say anything out of turn. So we are involved in that process. So I don't want it to be that we're not involved at all. So we are involved.
I'm good.
Any other
I'm not good,
questions? Okay. Well, I'm happy to answer any questions if you think of them later. So, Sure.
Thank you, Catherine.
That concludes the legal review of the presentation. We've got, members of the police department here to kind of do an update on the police department and answer some questions regarding the co-responder program and any other questions council might have, as far as PD operations go right now.
So I'm going to introduce Phil Snyder. He's one of our corporals. He took it over recently for the co-responder, so I'll let him describe what his position is. what he entails.
Sorry,
Yes.
Tammy, could you remove your mask, please?
Oh, sorry.
Where there's several of us up here that are having a hard time hearing.
Have it. So Phil is one of our corporals here, Phil Snyder, and he has just recently taken over 2 to 3 months ago. March.
Late March.
Okay, so he's taken over a co-responder, so he's gonna share some statistics with you and what he does. And Marcy is one of our Sol Vista clinicians, and she helps with that also. And I'll turn it over to them.
Thank you.
Good evening. So I'm sure you guys have all heard of the co-responder program. Maybe you don't know all the details about it, so I'll fill you in a little bit on how it works. The co-responder program is co-responder, so it consists of a law enforcement member and a mental health member. It's grant funded, doesn't cost the city anything. The contract we currently have now is going to go for another 2 years, and we plan to renew it as soon as that's done, so that this is an ongoing program. The main focus of this program is to help people that are in mental health crisis or behavioral health crisis. Crisis, I like to think of as a kind of a loose term, so that we're not limiting ourselves to the things that we respond to. Anyone that needs help, whether it be suicidal ideation, stuff like that, drug treatment, even people that just need help with living situations or homeless, these are all intersecting things that we deal with. So really the long-term goal is to get people into treatment. The hope with that is that the guys in patrol have to deal with them less. Does that make sense? Is there separate goals from like the mental health side that you guys are trying to get to? Okay.
I mean, it's essentially just ensuring that the officers have some support in detecting if it's, you're gonna have to step away, they want me to talk into it. Basically, it's trying to lessen the police officers' requirement to determine whether somebody is under the influence or in a crisis when they're not specifically, trained to recognize it, as well as Corporal Snyder and myself. And also then we're able to work with other community partners such as Sol Vista and Rocky Mountain to provide additional supports for the clients and hopefully decrease their possibilities of being incarcerated or involved with the police again. If by providing those resources, we can give them an avenue to meet, they're stealing food because they're hungry, well, let's get them in touch with the food pantry and show them the resources to help them get on their feet before they have to turn back to doing that again. So that's essentially.
So we haven't had this program for very long, but as of right now, the way the numbers are looking, we're going to average around 400 co-responder responses to calls every single year. That's not calls just dealing with mental health that the entire police department fields, but just the calls that the co-responder team will respond to. So if we think of that 400 number, about 200 of those are calls that can be handled right there on the scene without any further need for intervention. Maybe it's just, family dealing with an elderly family member with dementia or something like that, or they're having family struggles. Lots of little things that we can kind of deal with, right there on scene. The other 200 of those, and these are all approximate numbers because it varies from month to month. The other 200 of those, sometimes they end up in arrest or mental health holds, whether they're involuntary or voluntary. Or sometimes there's assessments done on scene, and those people are referred back into the mental health treatment system. So maybe we're not actually taking them anywhere for treatment, but we're still getting them enrolled in mental health treatment. And safety planning. Right now, there are 246 law enforcement agencies in the state of Colorado. There's only 26 agencies that have a co-responder program. So we are on the front edge of this. This is going to be something in another 20 years that every department is going to have. We're doing a great service for the community by having this program, and it's really a good thing for us to kind of be able to build this on the way that works for us and our community. Another good thing is considering the political climate right now and everyone calling for defunding of the police and to bring in different measures of dealing with stuff, that's another area that we're really ahead of the curve on. Do you guys have any questions?
Sure, Jim.
Well, first of all, thanks for, one, your service and your efforts. The 400 incidents that, or I'm going to call them contacts, or whatever you're going to call them, do you know of those 400, how many of those are with the same individuals? What's the percentage?
I had all the numbers. It's a very large Excel spreadsheet of numbers, so I didn't bring that in here. If I remember correctly, it's probably around 7 or 8% of the same people we deal with. That 7 or 8% deals with an even larger number of the total contacts. So that small percentage of people make up an even larger percentage of the number of times we have to deal with them. So a lot of people we might only deal with once, but there might be a handful of people that we have to deal with a lot. Those people are just typically they're slow to accept help.
Right.
And that's okay. We're going to be here all the time to help them. I don't mind contacting someone again and again and again and offering them help every single time. Eventually they might accept help, and that's our ultimate goal.
So what kind of data do you have that shows the impact of the program? I mean, are we in fact, if I recall correctly, the intent of the program was to offer, maybe two-sided, that was to offer people help that really wasn't practical for law enforcement to do it. And the second one was that if we could offer those people help, we're going to have a dramatic impact on the number of calls. What kind of data do you have that's showing whether that is or is not working? Or is or is not, is or is not a possibility of it working?
I just don't have the exact numbers on me with me right now. It does work. That is one of the categories that I account for in my statistics. Whether or not it helps the patrol officers get back into service for other calls for service. If I get called out to a scene, am I able to relieve those officers to go back to regular service? That's often the case. It just depends on the call. A lot of the things that we measure are very long-term, and
We've only just begun really collecting that data, so you're talking, we've only just begun collecting that data, so you're talking about 3 to 4 months of this detailed information where we are looking back. And this is something that DORA is also requiring of us.
Right.
On the counseling, on the mental health side of things. We are also, responsible to give them that feedback each month. And it's honestly, we're part of the pilot. There aren't many people that are even tracking this yet. So kind of early to give definitive numbers, but I can tell you from the people we've worked with, we do start seeing a decrease in how often they're contacting us, or even better, we see that they're calling us and saying directly, and saying, you know, you mentioned some resources, can I get that information? And this is no longer a police officer that's having to fill this, because we're here to do that. And we have been working on building those community relationships with other agencies and with, you know, DHS, so that we're aware of what they can provide as far as far as what they can provide to the clients. And so I think we'll see that information very, very soon. But I do already see, like I said, an increase in people willing to ask for help before it becomes a crisis. And I have also seen people that were thankful to have that opportunity to be heard. And I think it also de-escalates them to not have somebody necessarily in a full officer's uniform. And they become more informal with us, and they're willing to open up, and we're willing to get a little bit deeper than I think they would have before this program.
And Councilman Meisner, if I could, I would say there's another goal that's right there, equal with the ones that you mentioned, and that is to divert the people that are suffering from mental issues, or a mental crisis, mental health related crisis, from the criminal justice system, and get them into the appropriate level of services. And so the metric for that could be the number of people that have accepted help and are in on that side of things. And because it may be hard, given the variabilities of just society at large, to look at the number of arrests or the number of cases, contacts as a metric. But what we want to focus on is, are we getting the help to the people that are willing to accept it? And is there some number that we can look at that gives us that insight?
Yeah, I think the tracking is a little different. I personally think that the fact that you're relieving another officer is a wash. I mean, we're still, even though you're grant covered, we're still paying somebody to do it. The real benefit comes with, can we in a year say, we normally had contact with 53 citizens, and we're no longer doing that because those people have been helped in some form or fashion. Those are the kind of numbers I think are important, that those 53 people historically had 6 contacts apiece, and they're now not in the system anymore in terms of consuming your time and the other officer's time. And if we can show that, then I think the program then is showing some success.
So, Mr. Meisner, those statistics do exist. I just believe that Corporal Snyder doesn't have them here with us right now. I can give you an example of a particular success story without going into a whole lot of detail because of protected information.
Sure.
There was one individual, as this program was getting off the ground, that we had 28 calls on in 30 days. That individual is no longer in Canyon City. He, after some talking with Sol Vista, and at the time it was Officer Elliott who was working at that part of the program, that individual is now in a voluntary treatment program in Denver, where he's been doing quite well. I know that Corporal Snyder and Marcy have been in contact with him continuously through this. We haven't had any calls on that individual since then because he's been in a voluntary program where he's receiving treatment. That's one example. There are certainly other examples that are success stories, and I know that the program does have those statistics. I just don't know that we have them with us this evening.
I think the reporting is
Administrator
different.
Stevens has a comment here.
Yeah,
Let's get him in, Jim.
and Sergeant Walsh stole a little bit of what I was going to say. I was going to also just inform you that an update on the co-responder program was a last-minute addition to tonight's meeting, so they didn't come prepared with full statistics, but we can get those to you.
Yeah, I just think that the numbers you're going to give us are different than what we're accustomed to in terms of how we track things. We're looking for the success stories. I mean, that's what we're looking for, and that's why the program, in my mind, was created, is to get those people that truly need help out of the whole system and make their lives better. And if we can do that and document it, then that's the information that I'm interested in seeing.
Yeah. We'll be bringing, in the next couple of council sessions, the extension to the contract, and we can include some of those statistics when we bring the extension forward.
Great, thank you. Yes.
I do have a question. For those who would like to receive the help that they need, do we have access to the detox, to the mental health and behavioral health services that they need?
Normally, what we would do at that point, when we determine what the needs are, then we usually will call for a full eval from the mobile crisis counselor on duty at that time. And then they go through the process of getting them enrolled at Solvista if it's outpatient, or if they're going to detox in Pueblo or Springs, or if they're going for inpatient mental health treatment. That counselor is the one who follows that part up. We deal more in the community as far as, you know, helping provide those resources, and they do the hospitalizations. Of course, we work together, and I'm constantly in touch with whoever's on staff and saying, okay, well, more than like you're going to have someone up at St. Tom, or sorry, I worked up river long enough that I got it stuck. No, I was right, St. Thomas More. And, you know, let them know what's going on, and then we also will work with each other with recommendations and building that safety plan if they're going back into the community, helping them get in touch with family members or someone that can help them to abide by that safety plan. But ultimately, Solvista winds up doing the transportation through AMF or why am I messing everything up? AMR, thank you. So that they can transport them to the facility that received them. And oftentimes this means they're submitting 3 or 4 packets to different hospitals so that the doctor on staff at that hospital can review it and determine whether they are appropriate for treatment at that facility. Sometimes there's medical issues and things like that, so they have to keep going until they find someone that could accept that person. But I think we kind of streamline their part so that they don't have to be there for, you know, we're there whenever somebody's under the influence, where they come in after they have come down, because you can't get an accurate evaluation if there's substance abuse involved. So we are often the ones that say, yes, this is this. We need them to, you know, have levels below this before they can be evaluated. And then Solvista comes in to do those and take them where they need to go.
Okay, and do you feel like one set of co-responders is sufficient for Canyon City's needs at this time?
Probably due to COVID, yes. Will that number stay the same later? I don't know.
Yeah, it's hard to say for right now. I think we're managing okay. I know Canyon City is growing in size. It's hard to always define, you know, at what point another co-responder would be needed. Marcy and I both work kind of on the front half of the week, so to have someone available to work mental health on the back side of the week would certainly be beneficial. But I mean, we can cover all the stuff we you know, that happens, and we read all the reports and everything from the other side of the week, and we follow up with people, and you know, we're not letting anything slip through the cracks just because we're not working.
I remember when we accepted the grant at the very beginning, that a big part of that was to have interaction with the homeless population as well. Do you still have those interactions, and are you finding success in building those relationships to help them get the resources that they need?
Yeah, the interactions are definitely there. The homeless are a very difficult problem, as you're well aware. Some of them want help. I just spoke with a homeless person yesterday who I had in tears because he was begging for help. That's not the case with all of them. Some of them don't want help. We are still available as a resource, and I make sure that they understand that this program is there for anyone who needs it. It's just getting them to accept it.
Doesn't the grant come with funding to help provide for some of the needs that the homeless have, so that you can, whether they're vouchers or and things like that?
Yeah, we will provide tents for some that want to stay out and need to be protected from elements, make sure they have sleeping bags, clothes. But we do have funding available to help with incidentals if, say they're in crisis because they have one thing that they really need, then we're able to help them with that. And I have seen several people very appreciative of that and knowing that they were going to be okay because, they were able to get that met immediately versus, panhandling to raise the money for it or what have you. And then again, becoming involved with law enforcement because they're out and getting in trouble for it. So I definitely think we're seeing less involvement on that end. We also have had a gentleman that was obviously more in a manic phase and, looked as though he was breaking into vehicles, and we were able to go and talk to him and find out what was going on and keep that person from going into the system as well and making sure that they had the resources they needed to move forward. So it's definitely, I only started in late March, so, we're still getting a full fill of everything, but I think we've come together as a really cohesive team, and I meet with the mobile clinicians and crisis team for Solvista every morning, and they let me know of clients that were really concerned this person hasn't called in, keep an eye out, or, and I'll text and let Corporal Snyder, sorry, I call him Phil, so it's really hard for me, Corporal Snyder, to let him know, hey, or if it's a day he's off, I'll let Corporal Elliott, Sergeant Elliott, know, because since he is familiar with our program, he kind of helps fill that gap the days we're not there.
Thank you.
I have a quick question. Just with COVID going on and that, are you seeing an uptick in the number of people homeless coming to Kenyon? Or are numbers staying relatively the same, or is it decrease?
As far as homeless go, I think it's relatively the same.
Okay.
Yeah, I haven't really seen an influx.
Okay.
Yeah, I haven't either. I
No,
mean,
I
there's
was-
there's always some people coming and some people going.
Sure.
I haven't noticed a big influx due to COVID or anything like that, or influx at all. But kind of the same number coming and going.
And I know Loaves and Fishes has had beds available lately, and I know that wasn't the case last summer. So
Okay.
I'm assuming for summertime at least, we're seeing lower numbers than usual.
Good, okay.
Contrary to what we may read on Facebook.
Yeah, no, I'm not saying judgmental on it. I mean, I like to see them have beds. I think that is great. I want to see the help for all of them,
Yes, absolutely. There are resources available for those that need it right now, so that's good.
and we don't know what happened and put them in that position, so,
And it's not our place.
that's right.
Our place is to help them
Help.
get out of it.
I agree with you.
I'm just really proud that we're one of those 29 few in Colorado and that we're a pilot program and we're at the cutting edge for this. And we've had this for, has it been 2 years? Has it been 2 years that we've had this in place?
I think about 18 months.
18 months?
Yep.
Okay.
And I have a monthly meeting with the lady. This is a program run through the Office of Behavioral Health, and I meet with her. I communicate with her almost every day, actually, but I meet with her on video chat or a video meeting once a month, and they're still figuring out a lot on their side how this program is supposed to be run, and they're constantly making changes to the information they want to track, and they're on our side with it. All the people they have staff for that program all come from behavioral health backgrounds, and they're all in it for the right reasons, and it's still a program that they're working on building and stuff too. So there's always changes and stuff like that.
Well, it's nice to meet the new set of co-responders. So
Yeah.
welcome to the team.
Thank you.
Do we have, are there any other presentations scheduled here for tonight, or is that it?
You guys good? Yeah, I think that we've covered everything that we intended to cover tonight.
Any further questions from council? Council have any other questions, or?
Not for this group. Thanks.
I
Be
would like.
safe out there.
I'd
Thank
like to reiterate that. Be safe, and thank you very much for all of your efforts, what you do for our community. I know that I myself personally appreciate it, and I know that that's the feeling of council as a whole. And I just wanted to say thank you. And with that, we're adjourned.
All right, thank you.